How does that sound, folks? Okay, good. I can see folks now. Welcome, welcome. All right, so my name is Rachel Dean. I am the legal director of the Youth Justice Program at the Legal Aid Justice Center. And it's my pleasure to moderate this discussion today on seclusion and restraint and the new seclusion and restraint regulations in Virginia and the disproportionate impact of these harmful practices. Before we get started, I do want to introduce our panelists today. So first up, we have, oops, I think I've lost my descriptions here. There we go. Okay, so first up we have John Cimino. He is an attorney with the Children's Advocacy Unit at the Disability Law Center of Virginia, formerly the Deputy Director of the Virginia Board for People with Disabilities, where he worked on disability policy matters, including the regulation of restraint and seclusion in Virginia's public schools. And I think more of his bio is available in the materials. Next up is Lucy Trieshmann, a disability justice advocate, activist, a writer, speaker, and future disabled attorney. She is a third-year law student at the New York University School of Law, where she strives for the visibility and valuation of disabled people in all facets of society. And finally, I have Juliet Hiznay. Juliet is an attorney in private practice who has focused much of her work on the needs of children with disabilities and has recently been working on additional seclusion and restraint protections and protections for children who've experienced trauma in our public and private schools in Virginia. So welcome, panelists. I'm very glad you're here. All right. So we do have a set of questions we will move through to today. I do want to note first that the topic of seclusion and restraint can be a very difficult and challenging topic for people to discuss, particularly those with lived experiences in some of the systems that use seclusion and restraint. So I do want to provide that content notice for folks that we may be having some discussions that are hard to hear and hard to process today. Feel free to use the question box or the chat if you have any questions, but otherwise we will get started here. Let me launch the PowerPoint and we will have questions up on the screen for people. Okay. I'm going to share my screen now. Okay, so I want to ask panelists the first question, which is, what is the background of seclusion and restraint and the use of those practices nationwide in schools, institutions, and carceral settings, particularly against people with disabilities? Anyone want to step up and answer that first one?
Hi, this is Lucy. Sure, I can go for it. My name is Lucy. I use she, her pronouns. I'm a white woman with newly purple hair. And I wear glasses and I'm wearing gold earrings and a black top. And you might also see my black dog pop up behind me at some point, but he's currently asleep, so we'll see. But seclusion and restraint has always been part of the way that our society, our American society, treats people with disabilities, from institutionalization of people with psychiatric and mental health disabilities, which has been really aggressively fetishized by Hollywood and movies, but there actually is a very long legacy of abuse and mistreatment of disabled people in mental health facilities. So they use many forms of restraint, pharmacological restraint, physical restraint, etc. Mainly these facilities target women and folks with intellectual or developmental disabilities, IDD. They were first opened in 1752, actually by the Quakers, based on biblical conceptions of repentance. And this also relates to the infamous Supreme Court decision in Buck v. Bell, where Justice Holmes told us that 3 generations of imbeciles is enough. So this is the case that has yet to actually be formally overturned, that legalizes sterilization of people with intellectual and developmental disabilities, which actually took place in Virginia. I know we're not physically together there right now, but not too far from where we would theoretically have been if we were. And then moving more towards carceral manifestations as well. This came after, the use of seclusion and restraint actually came after this introduction of psychiatric institutions as well. So inspired by the Quakers. Solitary confinement in particular has been used since 1829 in the United States, also begun in Pennsylvania. Black men in particular are at highest risk of seclusion and restraint when they're incarcerated. And there's a very long history of abuse, death, long-term repercussions from seclusion and restraint of folks who are incarcerated. Almost 50% of those who are in solitary are Black men. And this relates to the shameless plug for a project that I work on called the Breaking Point Project. thebreakingpointproject.com if you're interested in looking, but we take stories of folks who are currently incarcerated or formerly incarcerated and have disabilities of any form, very broad definition of disability, and they share the awful things that happen to them. I've spoken with men who've been in solitary confinement for over a year. So very long history of that as well. And then moving into schools, in schools, it's presented as something that we use because there's a danger. So this child is presenting some form of danger, but what does danger actually look like? And are we really just interpreting the manifestations of some child's disability as dangerous? So there's a lot of really scary parallels between, in particular, what the police define as a dangerous person or suspicious person and symptoms of different disabilities. So kids in special ed in particular are 12% of the national population, but experience 75% of the restraint and 60% of seclusion. There's a really long history of segregation in schools as well against kids with disabilities. Prior to IDEA, kids didn't even have guaranteed access to the classroom. So trying to push back against that, and we'll get into later in the panel what's happening currently at the federal level and in Virginia specifically, but that's kind of a general overview. Oh, and then lastly, seclusion and restraint in schools can also lead to arrest, because that's not something that kids want to be experiencing. So they might fight back. And then that can lead to arrest, which introduces them to the juvenile system, which has been involvement in the juvenile system has also been indicated as a contributing factor to lifelong struggles with incarceration and targeting by the police.
Thank you, Lucy, for that background on seclusion and restraint. The next question I'm going to ask Juliet. So Juliet, we say the words seclusion and restraint. What do we mean when we use those words? What types of seclusion and restraint exist? And could you address some of the inherent dangers in those practices?
Sorry about that, I was muted. Sure, I want to say I'm a white woman. I have light brown hair, blue eyes, glasses, and I'm wearing a red blouse and jacket. I come at this from the private practice, as Rachel, you mentioned, and have had, unfortunately, quite a lot of experience with the aftermath of restraint and seclusion incidents in schools involving public school students. But this is not the first set of regulations that we've had in Virginia. There's also a set of regulations that applies to private schools. And there was an important guidance document that came out from the US Department of Education that defined seclusion and restraint. And they covered primarily physical restraint, mechanical restraint, and seclusion. So physical restraint basically meaning laying hands on to restrict the mobility of the student. So the student would not be free to move their torso, arms, legs, or head freely, but that does not include a physical escort. So that is the concept of a physical restraint in general. And then mechanical restraint is the use of a device or equipment to restrict the student's freedom of movement. Seclusion is defined as involuntary confinement of a student alone in a room or area from which the student is physically prevented from leaving, does not include a timeout. So those are the general definitions, which are pretty much mirrored in the state regulations as well. But when we think about what does this mean, and what are the societal uses and what do we actually see in the school systems, it's a little broader than that. Do you mind bringing up the slide, Rachel, for me? I had a slide that I wanted to show for this because I wanted to give people a visual. Again, this can be very disturbing to think about and to know about. But as we talk about the broader societal impact and we talk about what does this mean within a system, we know that this is happening in multiple locations and in multiple institutional settings, including schools. So here we have some visuals. The physical and mechanical restraints I described, but I have a picture here of the mechanical restraint. This is a chair designed to restrain. Some equipment can be used because it's needed for students. So we don't want to make a mistake of misunderstanding use. Although when we talk about, so for example, if there are wheelchairs, someone could be, that use could be inappropriate to the degree that it becomes a mechanical restraint. In other words, if you're left in the chair and you're not being moved adequately and you're not participating, and it's restricting your movement, so you cannot participate, that could become a mechanical restraint, even if it's approved equipment. So something that people need to be aware of for kids who are having those experiences. We also have electronic restraint tasers, which unfortunately at times have been used in school settings. There is no reference to electronic restraints in the guidance documents that the feds have put out or in our regulations here in Virginia. Same thing with chemical restraints, pepper spray, which I also believe have at times been used in schools. And those are also not referenced in any of the regulations or guidance documents. Pharmacological restraints are mentioned in the Virginia regulations, so that's good that that's mentioned. Obviously, we don't want drugs to be used to prevent students from participating in their school day. Solitary confinement and seclusion are pretty similar. One of the big differences in the way that those are defined under federal law and state law is the length of time. So solitary confinement gets defined within regulations usually as something along the lines of 23 out of every 24 days, hours in a day, which obviously is an extraordinarily long period of time. The restraint and seclusion, the seclusion piece in public schools, it doesn't have to be in a closed room necessarily. It can be in a corner away from someone, you're not permitted to leave. And you can see in this photograph, we actually have two things. We have a mechanical restraint in the form of the handcuffs, and we also have a student who's been secluded, placed away from other students and up against the wall, and obviously is not free to leave from that area. So you can, if you're not free to leave, someone has to be preventing you from leaving. It could be a door or it could be a person. And sometimes I think we get a little bit, there's a little bit of fudging that goes on in the way that that gets defined by schools. Many schools seem to think that if there is a staff person with the student, then the student is not secluded. I think that that is definitely a misunderstanding of the intent of the guidance documents from the federal government. Did you want me to talk at all, Rachel, about impact at this point, or we're just looking at definitions?
We are just looking at definitions for now, but there are some questions in about 2 slides on impact and particularly on trauma. Yeah. So thank you, Juliet, for that excellent overview of what we're talking about when we say restraint or seclusion. The next question I am going to ask John to address, which is, in Virginia, what have been some of the problems with seclusion and restraint in public schools, and what are the harms and disproportionate harms that have come about due to seclusion and restraint?
Yeah, hi, my preferred pronouns are he, him, his. I'm currently wearing glasses. I have shortish, dark blonde to light brown hair. I'm wearing a blue blazer, a white shirt, and a plaid tie. So for starters on this topic, I think it's important to point out that we really haven't had a complete picture of what the problems with restraint and seclusion are in Virginia, in large part because what we know is limited by the inadequacy of the available data. So there has, until very recently, been no requirement in Virginia for school divisions to document, track, and report their restraint and seclusion incidents at the state level. The U.S. Department of Education has for some time collected data on restraint and seclusion through their civil rights data collection efforts, but we know that that data is incomplete. We know that because of some well-publicized school districts who have reported little to no instances of restraint and seclusion when we've learned from subsequent investigative reporting that they in fact had quite a few. So the last year, for instance, for which this data is available was from the 2017 to 2018 school year. That year, Fairfax County reported 0 instances of restraint and seclusion, and we subsequently learned that they had somewhere in the neighborhood of 1,700 instances that year. So just to give you a sense of how inadequate the data that's available is, we know we're missing a large number of these instances. There also had been no common definitions of these terms in Virginia prior to the promulgation of recent regulations. And so we don't know how districts were interpreting when they were restraining or secluding students. We suspect that many students are being restrained and secluded by individuals who were not defining what they were doing as restraint or seclusion. So what we know about, and it's also worth pointing out that the CRDC data, they request information on the number of instances that have occurred. They disaggregate that by factors like race, gender, and disability status. But they don't collect data on, what happened prior to this restraint, what precipitated the restraint, what did the restraint look like, what happened prior to the seclusion, what precipitated it, what did it look like, what happened afterwards, what preventative measures were taken, what less intrusive interventions were used. And those are really important contextual issues that we really need to understand what's going on with restraint and seclusion. So what we know about a lot of these factors, we know from anecdotal evidence. We know from cases that either come to individuals for representation or that make it into the news. And I don't want to talk about too many of them, but it's worth pointing out one in particular that I recalled from several years ago in Virginia, where there was a 10-year-old child who had been secluded multiple times in a small cinder block room with a heavy locking door. The child was traumatized by this for obvious reasons. And the last time they attempted to seclude the child in this room, he attempted to claw his way out of the room. The teachers slammed the door shut, crushing his foot and hand in the door. His hand, there was a jagged bolt lock on the door that punctured his palm, exposing bone and requiring surgery in order to prevent bleeding. So this is how dire some of these situations become. We also know from anecdotal reports that in addition to the potential for extreme physical harm, these interventions have been used in instances where students' behavior posed no threat of harm to anyone else, often for behavior that could be described as disruptive, behavior that could be described as perhaps non-compliant, but not behavior that could be described as violent or threatening. We'll talk about trauma in a little bit, but just I think it's important to have this context in mind when we think about the traumatizing impact of these interventions themselves. Now, the CDC, the Civil Rights Data Collection, CRDC data, it does tell us some things, even though it's incomplete. We'd have no reason to believe that it's not a representative sampling of instances of restraint and seclusion in Virginia. And one of the good things about it is that the CRDC makes their data publicly accessible in raw form. So you can go in there and pull the data you want and crunch the numbers to see what's going on. And in preparation for this, I looked at what the most recent 2017-2018 school year data said just for Virginia on these matters, and really highlights the disparities in the use of these practices. In that school year, students with disabilities made up 13% of Virginia's student population, but 34% of those who were reported as having been mechanically restrained, 75% of those reported as having been physically restrained, and a whopping 95% of those who had been reported as being secluded. In addition, looked at the numbers for Black students. Black students made up 22% of Virginia's student population that year, but 66% of those who were mechanically restrained, 52% of those physically restrained, and 49% of those who were secluded. So when you look at this data together, it tells us several things. One, restraint and seclusion are too often used when they're when less intrusive interventions are far more appropriate, when an individual's behavior poses no threat to anyone. They have the potential to cause extreme physical harm in addition to the psychological trauma that they cause. And they're disproportionately used. This is a story, it's the same story that we hear in lots of contexts. This shouldn't be too surprising, I suppose. It's the same story we hear in the criminal justice context. It's the same story we hear when we look at data that looks at extreme disciplinary measures. It's the same story that we hear when we look at use of force in a variety of contexts. Students with disabilities and students of color are disproportionately affected by these practices.
Thank you, John, for that overview. And that leads us into the next question, which is the role of trauma here. What intersections exist between the use of these harmful and dangerous practices and trauma? And I'll open that up to any and all panelists who want to address that.
I'm happy to start. There's the very significant intersection between restraint, seclusion, and trauma. First of all, there's the developmental piece of what happens when this is done to a young child, or a child who is developmentally young, who may or may not understand that some condition that they're experiencing, some harm that they're experiencing, will come to an end. So it can have a much more significant impact on students with disabilities and younger children than the same kinds of actions would have on adults who are typically developing, for lack of a better term, or typical, I There is a very close connection anecdotally between the use of these practices and trauma, including clinical levels of trauma that in many, many students, and unfortunately, I've seen this in my own practice many times. It has some very immediate practical impacts on the ability to deliver services to students because the trust relationship is broken. And not only is the trust relationship broken between the student and the staff member who has carried out these activities, but it's also often broken between the child and the parent or parents, because the parents may not be aware that this is happening, or they may be told information by the school that is inaccurate or that leads them to believe that this is necessary, or even that it's a therapeutic intervention and something that will be helpful and will make the students, will improve their behavior. And unfortunately, parents often have a period of time when they don't understand what's really happening. A lot of kids with disabilities and younger children are not able to self-report. We have a situation oftentimes with children who are non-speaking, that they are unable to self-report at all. And some of those children are some of the highest risk for restraint and seclusion in public schools, because the barriers to communication can cause extreme frustration, and that often does come out as behavioral and gets described as behavioral. So it's really important. A couple of things are really important with this to know. One is that children need to be assessed after these incidents, and they need to be assessed by professionals. They need to be assessed to see if they have physical injuries, and they need to be assessed for emotional and psychological harm. And there are specialists in the field. I have seen children, young children, who even have post-traumatic stress disorder diagnoses, which is considered a lifelong mental illness as a result of the use of seclusion and restraint. And this is something that makes it very difficult for them to attend school and be productive at school and access their education. So it tends to be a kind of a self-fulfilling prophecy. You start doing it, and the more you start doing it, the more it becomes necessary in the minds of many staff, because the child acts out more as they have these terrifying things happening to them that they don't understand, and perhaps are unable to use language in order to advocate for themselves.
Yes, thank you, Juliet. And Lucy or John, do you have anything to add about the intersection with trauma?
Yeah, I want to piggyback on a bit of Juliet's statements there. I think you hit on some really important points. And one thing I'd like to add to this is, we know from research that looks at potentially traumatic experiences, what researchers call PTE sometimes, that the individuals who are most likely to have experienced potentially traumatic experiences in their lives, in their everyday lives, are students with disabilities. Research that's looked at these experiences among students with intellectual and developmental disabilities. There's research that's looked at this among students who have been identified for under IDEA regulations as a student with a disability. And they tell the same story, that these students are more likely to have a history of potentially traumatic experiences. And when you consider that with what we know today about trauma, about complex trauma, about trauma compounds, the more traumatic experiences you have experienced, the more likely you are to develop behavioral and emotional consequences from those experiences. And then, Juliet pointed out, I think very correctly, that this can be a cycle, right? And it's not unlike the cycle we see in the criminal justice environment, where we have interventions at times that seem to perpetuate rather than resolve the underlying problems at hand. And in this case, we have children more likely to have experienced trauma. Those same children more likely to have emotional and behavioral issues associated with that trauma. And then interventions that are intended to address the behavioral expressions of those issues that are themselves traumatic and therefore perpetuate that cycle. I think that's really a good way to frame that issue. So I appreciated that.
And just quickly adding on to that as well, I think it's important to note that being disabled in our society can often be inherently traumatizing. And so we're dealing with children who have already experienced probably some very negative things at the hands of the school system and doctors and other systems intended to support them, either through microaggressions or direct aggressions. And this is even worse for multiply marginalized students at the intersection of race, LGBTQ status, etc. And then speaking more to direct consequences as well, like there's well documented, unfortunately, instances of death, injury occurring from restraint and seclusion, but it's also been proven that restraint and seclusion can exacerbate long-term health conditions. In the carceral setting, at least, the odds of solitary confinement leading to even greater health problems are very high. So I spoke with one man who experienced suicidal ideation for the first time in his life while he was in solitary as a result of the conditions he was being held under, and has continued to struggle with it since. So I think that even short periods of seclusion and restraint can lead to intractable long-term consequences that truly can't be rationalized as contributing to any sort of safety.
Can I just jump in and add one last little thing about this? I do think it's important for people to be aware of the ACEs study, which is the Adverse Childhood Experiences study, which did show that there is a connection between physical health, medical health, and adverse childhood experiences. So, you know, anytime there is a question about adverse childhood experiences, which you can look online, it's very, many of these are very common things, like, for example, divorces could be one. You know, a lot of people think about neglect and abuse, and of course that fits the bill, but there's a long list of what those could be. And the more that you come into the school system with pre-existing experiences, the more likely it is that you're going to actually have, be prone to more traumatic experiences. And I think that the communication piece and that advocacy piece is so critical. When we talk about the intersection of ACEs and marginalized populations, Lucy, it's very appropriate to bring that up. You know, unfortunately, we don't have a panelist here to speak to that so much, particularly in terms of race. But the most severe cases that I see of isolation, seclusion, and trauma without any appropriate responses from staff that's allowed to persist over time often is, you know, when the student is a Black student with a disability. So, and it can lead to emotional disability being added. I see a very close connection between the failure to provide intervention, necessary intervention early on, and the likelihood of seclusion and restraint and developing emotional disabilities as they are, you know, defined under state regulations. So you end up with kids in more restrictive settings where they're also more likely to have seclusion rooms and restraint systems in place.
Thank you, all three of the panelists. Some accurate and compelling insights on that intersection. So I see there was a question in the chat about what sort of regulations or prohibitions exist, and that is actually going to be the next phase of this discussion today. So the first question is for Lucy. From a national and disability rights perspective, what are some of the current reform efforts aimed at ending these practices in schools, institutions, and carceral settings?
Yeah, absolutely. So I think we've seen a particular uptick in activism around these topics in the last year and a half since the murder of George Floyd at the hands of the police. And a lot of activism regarding seclusion and restraint in multiple settings has really taken off since then. In particular, the ACLU has a number of projects happening right now. The Stop Solitary campaign, they're also doing directed work on ending the use of seclusion and restraints in schools and removing police from schools because of the disparate impact that they tend to have on children with disabilities. But really, like, it's framed as what are the current reform efforts. I personally don't believe that there should be reform efforts. We should be pushing to abolish. We should be pushing to abolish seclusion and restraint in its entirety, and particularly the involvement of police in schools at all, because these are children. They're there to learn. They're not there to be criminalized for their disabilities and for existing. They're there to be supported and taught how to learn and how to become students and live the rest of their lives. So on that, it's also, there's a lot of legislation that's been proposed, particularly in the last year. We've had over 70 pieces of legislation proposed in 32 states across the country on removing seclusion and restraint or policing from schools specifically. So I think that we are seeing a large wave led by disabled people and also by parent activists and larger advocacy organizations with a disability focus. I think that this involvement of the disability rights perspective is going to be really important in combination with the racial justice and criminal justice reform abolition movement efforts as well.
Thank you. So for John and Juliet, let's bring it to the state level in Virginia. The two of you have worked along with a broad coalition of advocates here in the Commonwealth to try to get some regulations passed and some enforcement of those. So I direct this to both of you. What is the evolution of Virginia's current seclusion and restraint regulations?
I guess I'll take the first stab at this one, and Juliet can correct anything I get wrong and expand on where I fall flat. It's been a long process. Prior to doing law school, I worked for some years in an acute care psychiatric hospital in Massachusetts as a mental health worker, and I started that job in 2000, which was the end of the 1990s. There was a real focus on restraint and seclusion in psychiatric facilities in the United States. And it looked at a broad range of settings. They looked at regular hospitals, they looked at psychiatric hospitals, they looked at group homes. But for whatever reason, school settings were largely left out of that conversation. What we saw after that, so around I think it was either end of 99 or early 2000 that the Children's Health Act was passed, that and some other initiatives that strengthened regulation at the federal level of restraint exclusion in psychiatric facilities. And what we saw was that it was effective, that the use of restraint exclusion decreased, at least in the facility where I worked, substantially after that. Restraint in the facility where I worked, seclusion was not used. And I think it's somewhat telling that you can run an acute care psychiatric hospital without using seclusion. But individuals would suggest to you that they can't run a school without it. But after that initiative, in the 2000s, nearing 2010, that people started to realize that it's not just hospitals and psychiatric facilities where restraint and seclusion are used. This is used in schools, and a number of things came out of that. There were studies, there was legislative studies that came out of that. It renewed interest, and eventually the U.S. Department of Education published in, I think it was 2009, a document called the Restraint and Seclusion Resource Document, which contained notably 15 principles. And those principles included things like restraint and seclusion should only be used as a last resort when absolutely necessary to prevent imminent physical harm. I think that's probably the most important principle there. But there are others that were equally important in there. And it was in, Juliet noted earlier that there's separate regulation on seclusion restraint in private facilities that serve students with disabilities. And those, in one shape or another, date back to at least 2004. But it was in 2015 that the General Assembly in Virginia directed the Virginia Board of Education to promulgate regulations on the use of seclusion and restraint in Virginia's public school settings. And then some of you may remember the School of Rock episode on like how a bill becomes a law. They were going to do a follow-up to that on how a bill becomes a regulation, but the process was just too grotesque for TV. And this is a perfect example of how grotesque that process can be. The 2015, the law was passed directing the promulgation of these. Those regulations finally took effect in January, 6 years later, January 2021. And it was a long and messy 6 years. There were stakeholder meetings that became quite contentious. There was really strong disagreement on multiple sides of this issue. And what came out of it was an imperfect set of regulations. I can say that the final product was better than what was initially proposed. And it's no surprise that they're imperfect. Regulatory processes rarely result in perfection. There are some glaring issues, though, that need to be addressed, and we're going to get to those in a little bit. And I think we're going to address the specific pros and cons in just a moment. So I'll kind of leave it at that and let Juliet fill in additional context.
Sure, happy to. It's interesting because one of the dynamics that happened as part of the promulgation of the regulations was that we actually had legislators step in to ban a specific practice, and that became necessary because of the failure to really fully embrace the 15 principles and to really consider what and fully define what are the most dangerous types of restraints. So we had some legislative efforts in the interim as we were getting towards the end of the regulatory process, where members of the assembly felt really strongly they had to pass something in order to force the regulatory agency to actually take action on this. And I can tell you that many of us in the advocacy community, people who have been personally touched by this, people who have looked at thousands of pages of horrific documentation of what children experience in public schools, we had very strong opinions about some of the practices. For example, prone restraint, which is face down on the floor restraint, and even supine restraint, which is face up. Once you have a panicked individual down on the floor and you're holding them down on the floor, when do you let go of them? And what happens when you let go of them? There are instances of people being held in those kinds of positions for hours at a time. It can actually cause a chemical response in the body that can result in death. We certainly know that there are many other things that can result in death, like sitting on students and putting your hands on students. We see I see the very close connection between this kind of recognition of the dangers and what we know about the death of George Floyd, which, to be clear, was a prone restraint combined with a mechanical restraint. Okay, and that is what killed him. He had multiple spots on his body with the physical restraints, with the knees, you know, on compressing the neck and on the parts of the back. And then, of course, he was also handcuffed at the same time, which meant that his chest was compressed against the ground. You know, have had death, and in Virginia from, you know, with restraints. And these are some of the most significantly impacted children and the most vulnerable children that we have in Virginia. So when I think about, you know, the evolution of where we are, did we need regulations? Yes. Do they recognize the full scope of what needs to happen? No. And I'm actually with Lucy. I think that, you know, when you start playing around with, oh, do we need to protect property, or do we need to actually protect children from injury? Do we have these cute notions that somehow we're going to allow a timeout and we're going to redefine seclusion as a timeout? You know, these are all different discussions that went on during the development of the regulations. I'm glad that we got so much specificity on the aversive techniques. You know, these are things like withholding needs or punishing, you know, by removing certain things like maybe access to recess, this sort of stuff, right? Those need to be set out, but, you know, I'm with Lucy. I think that we need to be banning and eliminating this practice altogether and refocusing our efforts towards ensuring that the human rights of children are protected. This really falls into the human rights category, relating to the rights of the child to bodily integrity. And when we don't provide bodily integrity, we don't give respect to bodily integrity, then we are training our children that it's okay for adults to touch them and to control them in all kinds of contexts. And that has long-term, very serious and significant impacts. And we know that that's true in the criminal context. You know, children who are physically abused are more at risk of sex abuse later in life. There's many, many ways in which this can happen. But, you know, the regulations are not perfect. They're continuing to evolve, and will have to be, there will have to be a major effort to make sure that the loopholes that are in there actually get addressed. And that may require ongoing intervention for members of the General Assembly. In fact, I predict that it will.
So speaking of these imperfect regulations, what are the pros or the good things in the regulations, the things that are left out, and the loopholes? Juliet or John, I know you're very familiar with these.
John, why don't you take this? I just talked for a long time.
Sure. I'll point out some of them. So that first, point out some of the things that I think are important in the regulations. So one of them is the reporting requirements for several reasons. So mentioned earlier that we really need more accurate data on these practices. And one of the reasons we have such poor data is because there's been no state level requirement that people document and track and report these. We're still not going to get 100% reporting, but we're going to get, I think, much better reporting than we did when it wasn't a regulatory requirement that it be done. The parental notification was a big sticking point in this. There's a lot of debate about how quickly parents need to be notified. And we got essentially same-day notification for parents, which is a really good win and really important. The story that I told you earlier of the child who had been physically forced into a cinder block isolation room and locked in there multiple times prior to his injuries. His parents didn't know about that until he was injured because it wasn't reported to him. And we've heard that from other folks as well, that individuals were subjected to these interventions without even notifying a parent. These regulations require that parents be notified, which is really important for parents to be able to follow up on the physical and emotional well-being of their children, and to know when they need to address a problem at school that's not being resolved. There's one provision that we got into the regs that I think is really important is in the prohibited actions section. It is prohibited to use restraint or seclusion when restraint or seclusion is medically or psychologically contraindicated, as documented either by an IEP team or by a medical professional. I'm really interested to see the implementation of this piece, because I know that there are a lot of individuals now who are getting letters from doctors informing the school that that the use of restraint or seclusion on them is psychologically contraindicated or medically contraindicated. For instance, you can imagine why it would be psychologically contraindicated to use to seclude a student who has post-traumatic stress disorder from earlier instances of seclusion. And so you can imagine why that would be an important provision for those individuals. And hopefully, you know, again, we're watching to see how schools implement this. But if it's implemented, I think it's a really important provision within the regulations. There's also some imperfect but important preventative steps that have to be followed. So for students who are on IEPs or 504 plans, that the team has to consider whether those students engage in the type of behavior that would put them at risk of physical restraint or seclusion. And if they do, they have to plan, consider how to prevent that. The language could be stronger, but it's there. It's at least on the table. And then for individuals who've been subjected to one of these interventions more than twice in a school year, there's a requirement that if the child has a 504 or an IEP team, that those teams meet within 10 days. And if they don't, that a team be developed to meet, including the parent, principal, or their designee, the teacher that was involved. And again, these are imperfect, but there's a requirement that they meet and that they consider how to avoid the future use of these interventions. I think those are, in my view, the prohibited actions, which could be stronger but are there, the reporting requirements, and those provisions for prevention are probably the most important elements of the regulations taken together. But there are a lot of things missing from the regulations. And I'm not going to go over all of them, but a couple that I think are worth highlighting are, number one, there's no direct enforcement mechanism for these regulations. The regulations are there. They don't speak, there's no complaint process. So if your child has been restrained or secluded, there's no separate complaint process for that within VDOE. You may be able to find ways to enforce these. There are already, you know, the U.S. Department of Education put out a Dear Colleague letter years ago explaining how the use of seclusion and restraint can constitute a denial of FAPE under IDEA, and explaining how it can be a civil rights violation. It can be if it's on the basis of an individual's disability or race, and so, or other reasons. And so there are mechanisms you can use to try and enforce these regulations, but they're secondary mechanisms. They're not directly tied to the regulations themselves. I think that's a glaring issue that will need to be resolved eventually. Another glaring problem is SROs, which are excluded from the provisions of the regulations. There is a requirement, and this was kind of a quasi-win, not a full win, but a quasi-win. There is a requirement in the regulations that schools that use SROs have an MOU with the cooperating police department, and that MOU address the appropriate use of school resource officer. But it doesn't say what that MOU has to say. There is a model MOU that was produced, but it's optional. So it's not really, there's no teeth to that. And we know from news stories that SROs have been involved in really egregious incidents of restraint of children. And then I think, you know, I'm sort of a pragmatic idealist when it comes to regulations. And so I think we do need to keep our eye on the end game at all times, which is obviously prohibition of these practices. In the interim, I also think that there can be some wins in strengthening the language around when it is acceptable to use these interventions under regulations. So there was during the promulgation of these regulations, there was a really bad period, a really bad moment when there was an interpretation of an existing law banning corporal punishment, which states, you know, that nothing in this law will prevent a teacher from doing a number of things, including like using reasonable physical force to curb, I think, forget the exact language, like curb a disruption or something to that effect. It was really bad language. And there's an interpretation that those allowances in that statute had to be incorporated into these regulations. And it made for a really, really badly broad set of circumstances when restraint or seclusion could be used. That was thankfully defeated, but some leftover sort of hangover language from that is still in there. You know, one of the times that the regulations allow for the use of restraint or seclusion is to obtain weapons without defining what a weapon is, to obtain drugs or paraphernalia. What does that mean? We know from news stories that children in some schools have had disciplinary action taken against them for having Tylenol in their bag. Can they be restrained to obtain that Tylenol from their bag? What's paraphernalia? These are really, in my view, problematic language. I would much prefer, if not outright abolition, a clear statement that restraint and seclusion shall only be permissible when absolutely necessary to prevent imminent serious physical harm to self or others, and no other circumstance. I think that clear statement would be the only acceptable statement short of abolition, because we know that these interventions are so harmful. And so it blows the mind that you can justify a harmful intervention on a child when the harm you're trying to prevent is not itself as extreme as the harm you might cause. I can't wrap my head around that one. So I'll leave it at that and let Juliet or Lucy or anyone else add some more.
Do you want to jump in here, or should I go on the Virginia piece? Okay. So, you know, one of my big bugaboos is the timeout, which I already made reference to, but another really significant piece is holding students in seclusion pending investigation. And, you know, that's one of those things where you've got a student who's been, you know, let's suppose they've done whatever it is they're accused of, right? Has just been caught doing something. They know that they're in deep trouble. They know they're being investigated. Most of these students would be, and they're probably terrified. You're going to leave them alone in a room during that period of time when they could be at high risk for self-harm. That just, to me, is completely outrageous. But there was a very big pushback from school divisions saying, we have to be able to put a student in one room and then a student in another room so that we can interview. And again, this kind of goes back to, how do we handle investigation? How do we handle, you know, disciplinary matters in the school setting? Are we going to treat this like this is some kind of criminal investigation? Because, you know, it became obvious to me as soon as I started doing this work that educators are not good criminal investigators. They're not good at it. They don't have the training for it. And I don't care how many workshops they go to, they're never going to have the training for it, you know, because they just don't know what they're doing. So you end up with these bizarre situations in disciplinary settings where kids can actually get railroaded out of school, even if they win their case in criminal court. And we do see that there is this very clear connection between the restrained seclusion and loss of time in school, time out of school, long-term suspension, right, or expulsion, and a path to school to prison pipeline, meaning that once you start isolating students, you start marginalizing them, it makes them that much more likely to end up in prison in the long run. And that has been studied, and we have a lot of data on that. And there was a very significant hearing that was held, and I think it was 2012, by, I think it was the Judiciary, Senate Judiciary Committee. You know, we have so much data around what that causes. So these loopholes are not nothing. You know, what is timeout if it isn't being put in a place where you're not free to leave? I don't even know what that means. How could they define timeout as being separate from a seclusion? I don't get it. You're being turned to the wall and you're not free to leave. And if you try to get up before it's the right time, then you get sent back. That's seclusion. Under the federal regulations, that's seclusion. And it should be seclusion under the state regs. So, you know, other pieces that concern me, there are many of them. I think it's probably, we don't have time to cover all of them today, but sometimes what can happen is that if you have these ad hoc implementation measures all across the Commonwealth, where now every single school division has to have their own regulations, or their own set of rules that they apply in response to implementing these regulations, means that we may have a patchwork quilt of very different situations across the Commonwealth. What's that going to do to our data? That's not really good for data. I would rather see some more specific paperwork provided and made mandatory at the state level so that we have consistency across school divisions. We know exactly what has to be documented. We know exactly how these things have to happen. On the other hand, it's an opportunity for local activists to get specific and more restrictive measures in. I know that some school districts in Northern Virginia are essentially banning seclusion or in the process of banning seclusion, which is a good thing. So I think we still have a work in progress, right? And many people feel we're going to see a much bigger jump in the numbers immediately coming out of this, because we're going to have more reporting and more awareness around these issues. So we're going to see probably a pretty significant jump. Keeping in mind, we won't know about it for some time, right? Because the federal reporting, it's going to be at least 4 years, I think, before we're going to have numbers.
So, you know, Juliet, you ended on a somewhat hopeful note there of looking toward the future, shedding more light on these practices. So final question, and I do want to reserve some time for audience questions at the end here. So 1 minute each panelist, what is the next frontier for advocacy on these issues?
I don't mind starting. I think that combining efforts between the fight for decarceration, prison and police abolition, and for the elimination of seclusion and restraint and police in schools, I think that all of those need to be combined. And I also think that it's incredibly necessary that we take an intersectional approach and understand that these issues don't impact all people the same. And would also like to see us move more towards a community-based model where we're listening to folks who are directly impacted and taking steps forward based on what it is that they would like to see happen, as opposed to what it is that attorneys think is legally feasible or what they think would make a good case.
All right, I'll jump in quick. I think there's 3 lanes to travel from here forward. It's enforcement, data, and policy. And so we have these regulations now. There's no firm enforcement mechanism, but we know that there are creative avenues to try and enforce these regulations, and it's incumbent upon those of us in positions to do so, to try to do so. Then we're going to have this data. Some of it, as Juliet noted, won't come for some time, but some of it will be available at the state level in relatively short order, at least once we've had kids in school long enough to get meaningful data out of this. And so it'll be available, if not made publicly available through FOIA. I think we need to get our heads around what's going on now that this data will be available. And then policy change at the local, state, and federal level. School boards are required to adopt policies and procedures. They can be more strict than the state regulations. And some, as Juliet pointed out, some school divisions have put in place stricter regulations. Some have abolished the use of seclusion in their districts. And we need advocates on the ground pushing for that at every school board in the state. And then we need advocates pushing for that at the state level. And then every year, there's federal legislation attempting to regulate these things at the federal level. And I think we need advocates at each of those levels pushing for the outcome we need.
Yeah, so I want to real quickly, I think there's two things in particular that are the next frontier in Virginia specifically. One is that we have to broaden the scope of the focus of the harm and what we want to prevent in seclusion restraint regulations to cover students who are not in the disability community or haven't been identified, because we already know that we have disproportionality, particularly in the Black community. So that is something that is extremely important. The other piece is understanding very clearly that we are educating students in detention centers in this Commonwealth, and we have a crossover issue that has been carved out for detention centers. This is the same harm that is going to happen to anyone in a carceral setting, and you can call them something different. You can say that they are, meant to be, supportive settings. But let's be clear, the settings that we have in Virginia are prison-like settings for youth, for the most part. And these practices are happening in those settings. We've got to understand that this is a broader issue and stop dividing, the concept of how restraint, seclusion, solitary, how those things are being handled in these different settings. We need to broaden the scope and understand that this is a human rights issue across institutional settings.
Thank you all. Thank you so much for the conversation today. I've been working on these issues some, and I learned new things today, and I hope the audience did as well. We do have a few questions in the chat, and please, anyone, feel free to raise your hand electronically or put more questions in the chat. I see one. Are there any proposals for the General Assembly 2022 session that should be on our radar?
I don't know specifically. I know that a lot of the legislation gets dropped usually in mid-November, so I think that we're a little premature. I don't have any specific information about that. I do know that there has been some focus on juvenile detention in various localities, because we did have, we had an investigation involving youth who were in immigration detention in Southwest Virginia. There's been some attention focused on that. So when I talk about carceral settings, I also mean immigration detention. And so let's understand that youth are in these institutional settings all over the place, and we could see changes in health regulations. We could see it in our prison regulations, in all different kinds of contexts. And these are now different pieces of the Virginia Code. So it could be a long haul and there may be a lot of different provisions from a lot of different people, but I think one thing that the General Assembly should consider immediately is mandating an avenue for civil rights complaints before the Virginia Department of Education and funding it, because I'm tired very tired of the little annotation at the bottom of our responses that says, you can bring this issue to the Office of Civil Rights in either the Department of Justice or the Department of Education, and this is outside of our jurisdiction. Well, I don't know. Are they enforcing civil rights law or are they not? I would like to see that.
Hear, hear. I I wholeheartedly agree. I would also say, you know, it's past time for a much more robust state complaint process at the Virginia Department of Education as well. We have been challenged many times trying to do client advocacy in that forum. The other thing I will say in response to that question, just from my perspective, is, you know, there is a lot of ongoing work, not only in the General Assembly, but at the local school division level around the use of school resource officers, and, you know, ultimately abolishing those roles in schools and you know, getting police out of schools and away from harming students. Are there any other audience questions? Well, with that, we will wrap it up. Thank you so much, Lucy, John, Juliet, for a really informative and helpful discussion this afternoon. And everyone, have a great evening.
Thank you, Rachel.
Thank you for moderating, Rachel. Thank you so much.